right, so Jello again. This is Ben Hitchcock Cross talking to you. We are back in Missy Zombor. This may be jumping around for you. I don't know. I think we're in part 3 here. And so if you recall, we had sent all the witnesses, including Missy Zombor, a letter saying, contact us and we'll get you scheduled up. Instead of contacting us, she contacted her co-counsel, didn't say anything to us. And at the end of day 1, the co-counsel sandbagged, or the opposing counsel sandbagged us and said, hey, judge, you need to make, she's been waiting all day. You need to make them take her in the order that we decide, because to be fair to her. So then we're trying to find out, did you actually get this document and did you review the thing and then chose not to contact us? And the judge is preventing us from asking her about whether or not she got that letter. Okay. All right. At this point, well, counsel is not on trial. This is not a free-for-all to attack the opposing side. So at this point, we're done asking questions about the subpoena, and we're going to move straight to what this witness has to offer on these claims that your client has made in this complaint. Okay. Question. So you don't deny that you've talked to these attorneys, ALJ DeFort. I've already ruled that it is now moving forward irrelevant. You're going to move into your questions. Why is that irrelevant about your claims? Why is that question whether or not this witness, it's irrelevant and immaterial? Why is it irrelevant and immaterial? Because I said it is. We're moving into, I understand. Now the claims. Oh, okay. So I got it. So we can't ask her about the preparation to this. Move on. Subpoena in any way? Question mark. Move on to the claims. Okay. Well, so again, I want to be clear. I can't ask her about the subpoena in any way anymore. ALJ DeFort, I'm not allowing you to ask questions about the subpoena and her privileged conversations that she had with her attorney. Oh, so see, now it's moved on to the subpoena and the privileged conversations. Mr. Hitchcock Cross, nobody asked her about her privileged conversation that she had with the lawyer. ALJ DeFort, that's the area you're swimming in, so I'm asking you to ask questions that are relevant to the claims of your client. Okay, so again, you won't allow me to ask this witness if she, ALJ DeFort, I'm not going to repeat myself. Mr. Hitchcock Cross, talk to these attorneys, correct? ALJ DeFort, I've already made my ruling. Move forward. Mr. Hitchcock Cross, okay, well, because your ruling stated, ALJ DeFort, move forward, Mr. Hitchcock Cross, that I couldn't ask them about her conversation. I didn't ask them what the substance was of the conversation. I only asked if she had the conversation. So I need to be clear that you're not also asking me, letting me ask that question. Ms. Colbert, I'll also say asked and answered. She did testify that she spoke with us, and which precipitated all this drama. ALJ DeFort, she already answered that, but it's not relevant. So let's move forward to the relevant information that I think you probably have from this witness. Mr. Hitchcock Cross, okay, just to be clear, bias of the witness is not relevant. Fairly good question. And whether a witness is communicating with somebody improperly is also not relevant, just to be clear, right? ALJ DeFort, that's not my ruling. And let's move forward. Mr. Hitchcock Cross, well, I need to understand your ruling. So can you clarify? Well, my ruling is already stated on the record that area you are delving into is not relevant. Mr. Hitchcock Cross, got it. Okay. Question. So did you provide an absence slip, or let's put it another way? Are you being compensated for your time here today? I'm going to object to the relevance of that. Oh, and this is what a good, this is actually a fair question. Okay. This is considered board business, my understanding. Just to be clear, I want to object to that characterization because it implies that my other questions were somehow unfair. Question. Okay, why do you believe, Miss Edie, that this is board business? Because I was subpoenaed to come here for this hearing here today. We are clearly not in the Mrs. Onboard testimony. We're clearly talking to Miss Carol Edie. But that's how it goes sometimes. I guess there's more than one so at this point. Have you consulted with anybody about whether you're going to get paid for your testimony here today? No, I have not consulted with anybody. Okay. Well, how do you know that you're going to get paid? Because it's board business. Because at any time that we're subpoenaed to come, my understanding is that it's considered business, board business. How did you get that understanding? I consulted with somebody at our employee relations department. Okay, when did you do that? The day I got the subpoena. Who did you consult with? He is the director. What is his name? Larry Cote. Got it. Okay. What I'm guessing, but I take it that you have worked for MPS. Is that true? I do work for MPS. When did you start working for MPS? In November of 2017. Okay. What was the position that you held at that time? Senior Director of Benefits, Pension, and Compensation. What job did you hold before that? I was employed outside of Milwaukee Public Schools. I was a director and a benefits director. I got it. And with what organization? Fortis Management Group. Do you have a different position at MPS? Yes. What is that position? I am the interim chief human resource officer. Okay. You hold a position that Adria Manalini once held. Is that true? That is correct. She's higher than Larry Cote in the same like line, and she's consulting. Okay, got it. And when do you see in 2025 January? Is it fair to say you're now the interim head of HR? True. I am the interim chief human resources officer. Oh, okay. What experience do you have with HR? I have 20 years of experience working in HR. And with benefits or something else? Benefits, including employment relations, I've had experience with all of those areas. Oh, good. And you've conducted employment investigations. I have done employment investigations before. Have you done employee discipline? I have done in my previous role, yes. And what previous role? When I was at Fortis Management Group. So you don't have any experience doing discipline at MPS, true? I have done employee disciplines at MPS. Have you ever done employee investigation? No, I have not. Okay, now in your role as head of MPS, you know that MPS has two separate HR systems, right? Two separate HR systems? That's right. What do you mean? What systems? I'm not understanding what you mean. You don't believe that to be true? Question mark. I'm trying to understand two different systems. Can you clarify what systems you're talking about? Well, you know that what employee relations is, right? Employee relations is a department? Okay. And it's got two different departments at least, right? No. Employee relations is part of HR. Got it. Is there another department that's under HR? Yes, there are several departments that's under the umbrella of HR. Great. Name them, please. There's rights, employee relations, MPSU, talent management, pensions, benefits, and compensation team. And that's where you were at was before was benefits and compensation. Yes. Okay. So now you supervise MPSU. True? I am the chief. I don't supervise them directly. They're under the umbrella of HR. So you supervise the people who supervise it, right? Correct. Okay. So what experience do you have with the university? I don't have a lot of direct experience. Got it. With the university. And then employment rights. Explain to me what that is. That's an area where employees can come and file a complaint if they think they're being harassed, bullied, anything of that nature. Now, let's say when an employee makes a complaint, that's Yashika Spears, MPS watchers. Now, let's say when an employee makes a complaint to employee rights, there's no possibility of the supervisor being disciplined. True? Can you clarify what you? Sure. If I make a complaint and I go to employee rights, employee rights is going to investigate my complaint, won't they? But they will not be able to take any action against the supervisor. They can recommend that there's an action taking place, yes. Like coaching, for example, right. Coaching, or if there's misconduct, there's discipline. Uh-huh. Employee rights can recommend discipline, is that true? Employee rights will work with our employee relations department. Okay, so it's only employee relations that's the one that can do discipline, right? Correct. Question. And you knew that when I asked you that question before about employee rights before, right? Objection, argumentative. ALJ default. Move on to your next question. Mr. Hitchcock Cross, how is that argumentative? I don't understand what the issue is. Miss Colbert, she answered the questions. You're confronting her about the way in which she posed her answer and are asking if she knew when she was answering the questions that she's already answered. It's by definition argumentative. No, that's my job. It's by definition. I mean, argument is not something that's unpleasant. It's making a legal argument that's in the form of a question. So, what legal argument is there in that question? It's not a legal argument. Your tone is argumentative, it's confrontational. She's answered the question. That's the basis for the argumentative objection. Right. Also, Judge, that's my job to be argumentative. That's what she's describing is not the actual objection of argumentative. It's a Wisconsin version of it, which means that there's something I don't want to hear. That's not the same thing. My job is to confront this witness with her misstatements or false statements. That's what I do. Miss Kohlberg, it's not your job to harass and intimidate the witness who's trying to provide evidence. Okay, now the argumentative point of it, in addition to what the respondent has said, is that it insinuates a motive to lie by the witness when you can simply confront the witness with whatever it is that you believe is the misstatement or false information. So it's unnecessarily argumentative. Please move on. I get it. To any confrontation that you've got. I've got it. Okay. So, employee rights, I guess that's the question there. Do you think this question that says, you knew when I asked you this question, you knew what the actual answer was, that employee rights is the only one that can do discipline, and that there's two different sections? You knew that when I asked you those questions, and you were pretending like you didn't know, right? That's the confrontation. Okay. So employee rights can't take any action, right? Employee rights will work directly with the employee relations department. Question, right? Answer, when you do, does HR tell employees that the most that employee rights can do is order coaching? No, that's not my understanding. No. Okay, so the employees don't know that, right? Question. Employees don't know? They don't know that if they make a complaint to employee rights, that no action will be taken other than coaching. The employee is not informed. The employee that makes the complaint, right, is not given the details of what action is taken against the person. Right. When they make that complaint or after they make that complaint, right? At any time, either before or after. And not only as soon as the person makes a complaint to attorney rights, employee rights goes and tells the person that they made the complaint against. True? There's an investigation that's done. Can you answer my question? Restate your question. Sure. If I were to make a complaint at the employee rights office, employee rights would tell the person that I made the complaint against. True? Answer. No, they don't tell that person. My understanding is that there's an investigation that's done. Okay. And so the purpose of the investigation is to investigate, right? It is to investigate. Okay. But at no time is the person who is alleged to committed the act notified of the person who complained against them. Is that true? Answer. My understanding is that they are not notifying that the person that the complaint is against. There's an investigation that's done. I got it. What steps does HR take to protect the anonymity of the person who made the complaint? I don't have all those details. I don't have all those details. This is the head of human resources. Okay, well, I understand. So as an employee, can I make a complaint to employee relations, question mark? Yes, you sure can, yes. Okay. And then it's possible that the complaint might actually lead to discipline. True? Correct. That is correct. Okay. And who's the person that determines whether or not a complaint to employee relations makes it leads to discipline? That is discussed with the manager over employee relations and the director over employee rights. I got it. And so let me be clear then. If an employee of MPSU makes a complaint against their supervisor, who is actually the person that the complaint would ultimately go to? It depends on which department. Oh, like the two different departments. If the person contacted employee rights or employee relations, question, and before you go there, I know that it's employees. And as you said, that employees are not told that employee rights will only lead to coaching. Do you believe that employees are told that if they file a complaint with employee relations, that something might actually be done about the complaint? They're not. Restate your question. I don't understand. Sure. As an MPSU employee, as an employee of MPSU, how do I know which avenue to take to get something done about my complaint? Let's say I want more than just coaching. Okay. What do I do? You would go and file a complaint. So just to be clear, the employee relations, the employee rights department is a subdivision under employee relations. So it's the same department. Oh, okay. So Larry Cote oversees both areas. Got it. And Larry Cote, what's his job title? What's his position? He's the director of employee relations. Got it. Okay. And there's a head over MPSU currently, right? Okay. And what's that person's name? Jonathan Tempesta. And what's that person's position? He's the manager. Is that person a peer of Larry Cote or something else? He would be one step below Larry. Okay. So Larry could direct him, Tempesta, to be disciplined, right? He could put in a recommendation for him to be disciplined. Okay. And then who would that recommendation go to? That recommendation would then go to the senior director over talent management who oversees Tempesta. Okay. And that would have been Michael Harris up until some months ago, right? That is correct. Okay. So all of Teresa Folaron's complaints against Jonathan Tempesta would have ultimately gone to Michael Harris. Michael Harris, by the way, is one of the persons alleged to have participated in the discrimination against Teresa Folaron. He would have been consulted with Michael Harris. That is correct. Question. So not only consulted, the decision about whether to take any action would have ultimately made by Michael Harris. True. The recommendation comes from Larry on what action should be taken. Okay. And that information is shared with Michael Harris. Okay. Or whoever is the senior director at that time. I got it. What is the purpose of sharing that information with Michael Harris? Is it for fun or something else? It is to inform him if there's any misconduct or discipline that's going to be taken against somebody that reports directly to him. Okay, now when they inform him of this information, is it usual that the person then that Michael Harris makes a decision about what they do, or are they just informing him for no reason? The recommendation is made by Larry Cote. Uh-huh. And if it's serious enough of misconduct, he would recommend whatever action. And typically the senior director will agree with that decision. Got it. Or there's some discussion, but normally the recommendation, it's coming from Larry Cote. Got it. Okay. But it's ultimately Michael Harris's decision. True? In most parts, it's Larry's Cote decision. He's the one, he just recommends. He's recommending, and depending on the nature of whatever the situation is, he's going to be strongly recommended that we take the action based off of. Got it. So whether or not Michael Harris is acting as a rubber stamp for Larry Cote, it's still Michael Harris is the one that's stamping the document. He's the one that's making the decisions, right? And finally, here we go, 20 minutes. He would have to sign off on it. And when you sign off as decisions as the HR chief, right? And when you sign off decisions, are you using your brain when you do those decisions? I'm going to object, argumentative. It's marginally relevant. So please go ahead. You can answer that. I'm using my brain. Okay. And when you sign a document, that indicates that you've used your brain and you agree with that document that you signed, right? Yes, I've just had a conversation about what is the situation, what is the case, and what is your basis for whatever recommendations. In some cases, I will. Most cases, I agree with him. Some cases, he'll say we can do either this or that, and then I'll say go with his recommendations. He could say do with this, and you can say we're going to do something completely different. I do not do that. You could do that. I could do that. You have the authority to do that, don't you? I do. So whether or not you make that choice, it's based on your authority. Correct. Thanks for sticking with us. We'll keep you informed.